Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on credit. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can follow me on TikTok and Twitter at attorney_bay. So, in the South African space or the South African context, when it comes to offering credit, we know the most important law is the National Credit Act. So, the National Credit Act deals very well with credit. So, it sets out, what the rights are of consumers who are being offered credit, what the obligations are of institutions that offer credit to consumers, what were to happen if a institution offers credit to a consumer rather who doesn't afford credit. It also deals with debt counseling and so forth. So it deals very well with credit in South Africa. We do also know that the body or the institution that deals with the offering of credits in South Africa is the National Credit Regulator. So when it comes to credit, really, as you may know, credit may be offered in various forms. You can be given a credit card, you can be given a bond for your property, you can also be offered vehicle financing by a bank or any other institution that is qualified to offer credit to you as a consumer. Now, when it comes to credits in the South African space or the South African context, we know that according to the National Credit Regulator, institutions that offer credits to consumers have various boxes, boxes to tick when offering credits to consumers. Very important is that when an institution like a bank offers credits to a consumer, number one, the bank or any other institution offering credits to the consumer must actually ensure that the consumer is aware of the risks and the costs that are associated with that credit that is being offered to the consumer. So, an example, you go to the bank or you are offered a credit card by the bank. The bank actually has an obligation as a credit provider to ensure that you understand what are the risks of having a credit card and what are the costs of having a credit card as a consumer. So, you need to understand, or they need to explain to you, they being the bank, needs to explain to you, what are the costs on a month to month, what is the interest that accumulates on that particular credit card, and what would happen if you were to default or not to upkeep with the payment of your credit card as required. Number two, the institution offering credit to a consumer must ensure that a consumer understands their rights as well as their obligations in terms of that particular credit agreement. So, an example, you are being offered vehicle financing by a bank. The bank must ensure that prior to you signing your vehicle financing agreement, you understand what your rights and obligations are in terms of that vehicle financing agreement. So the bank actually needs to explain to you, and this needs to be done before you sign, that vehicle financing agreement. What are your rights? For instance, if you were to default, what are your rights in terms of not affording or being able to keep up with the payment? What were your rights if you were to be in breach, in other words, non-compliance with your vehicle financing agreement, and of course, as well as your obligations as a consumer. Now, your obligations and your rights may vary. Some of your obligations may include making sure you pay your vehicle on a month to month, making sure that your vehicle is insured at all times or for the duration of your credit agreement, ensuring that if you are going to make modifications to your vehicle, you have the prior written approval of the bank that had offered you credit. And some of your rights as a consumer, of course, is you have a right to a cooling off period, as discussed in the Consumer Protection Act. What the cooling off period essentially does is that if a consumer purchases an item and they change their mind about that particular item, you have a certain number of days within which you can actually return an item. So it's a Monday afternoon and you purchase a vehicle that you really like, and on Tuesday morning you wake up and you realize that I actually don't like this vehicle and I'd like to have it returned. So the Consumer Protection Act enables you to actually return that particular vehicle, and any monies that you may have paid in relation to vehicle financing must be returned to you. And of course, you as the consumer have an obligation to ensure that you return the vehicle to the particular a dealership that had offered you the particular vehicle. And of course, the bank, like I mentioned, any money paid must be returned to the bank. And of course, whatever item that you had acquired, you have an obligation to ensure that you return that particular item. Number three, when it comes to offering credits to consumers, is that a bank or any other institution that offers credit must ensure or have a thorough background search on that particular consumer. So the bank actually needs to request documentation like they usually do, your payslip if you are an employee, or any other means within which you can prove your source of income to the particular bank. The bank also actually needs to check or verify that the information that you had provided is correct information. Banks or any other institutions who offer credit to consumers also have an obligation to actually do not just a thorough search, but they need to check your existing financial means. So it's not just your 3 month bank statement. It needs to be at the time you make the application. What are your existing means? And more important, perhaps, is that by offering you credit, an example, if the bank gives you a bond that you would be paying over a 20-year period, at the time that the bank offers you the bond, are they not making you over indebted? In other words, they are putting you into too much debt. So you might rather, as a consumer, already have debt, but credit providers also have an obligation rather to ensure that when they do offer you credit, they are not making you over indebted. In other words, putting you in too much debt. When it comes to credit agreements, like I'd mentioned, credit can be offered in various forms. An example being, a bond which you pay on a month-to-month basis. It can be through vehicle financing. It can be through a credit card. Now, in the South African space or in the South African context, we have what we term as a reckless credit agreement. So, what reckless credit agreements are essentially agreements or contracts where a credit provider, like a bank, had offered credit recklessly to someone who actually doesn't afford credit. Now, I've just gone through some of the obligations or requirements that a bank or institution offering credit to a consumer has. So what we know in South African context is that when an agreement is declared a reckless credit agreement, the institution that had offered credit, obviously it means that they didn't check the requirements when offering credits to that particular consumer. So in the South African space or the South African context, we have three classifications for reckless credit agreements. Number one, a credit agreement can be deemed a reckless credit agreement if no history or the history or repayment history rather of a consumer was done when offering credit. Again, example, you're taking a credit card with the bank has an obligation to check your repayment history, your existing financial means, affordability. If they offer you the credit card, would you be able to keep up with payment on a month to month? If that verification process was not done by the bank, it could mean that particular credit agreement is a reckless credit agreement. Number two, a credit agreement can be classified as a reckless credit agreement if a credit provider, example the bank, did do the thorough search on a consumer. In other words, your background search. They verified your income, through bank statements or any other documentation that you had provided to the bank, as a means within which you are showing that is your source of income. But even after doing that history, they were aware that by offering you credit, they would make you over indebted, but they nonetheless offered you credit. So put in very simple terms, a bank offers you credit, or rather the bank does do the background search on you as a consumer, but they realize that, for instance, by offering you vehicle financing for a car, they would make you over indebted, but they nonetheless offer you credits. So that's the third actually classification of a reckless credit agreement. The second classification of a reckless credit agreement. So the second classification of reckless credit agreement is if a credit provider, example a bank, offers credits to a consumer, and by offering credits, they offer credits to a consumer, and they did do the background search on the particular consumer, but by offering credits to that consumer, they are aware that that consumer cannot afford credit. So like I mentioned, there are three classifications of reckless credit agreement. Just to recap, number one is that you're offering banks or institutions offering credit to consumers without doing a thorough search on a particular consumer. The second being that you do the thorough search on the consumer, but you choose to offer credit to the consumer although you're aware that the consumer cannot afford the credit. The third classification of a reckless credit agreement is when the credit provider does do a thorough search or a search, background search on the particular consumer, and they offer the credit to the consumer. However, they know that by offering credit to the particular consumer, they would make the consumer over indebted. In other words, you'd be in too much debt. So, like I mentioned, the National Credit Act places various obligations on credit providers who offer credit to consumers, and it is very crucial that prior to offering credits to consumers, a proper background search is done on that particular consumer. So the banks need to actually verify, your affordability. By offering you credit, are you not getting into yourself into too much debt? By offering you credit, are you able to upkeep with the payments on a month to month, or in accordance with the terms and conditions? As a consumer, do you understand the rights and obligations that you have? Do you understand the risks and the costs that are associated with the credit that is being offered? So, as mentioned, when it comes to credit, we have the National Credit Act that regulates credits in South Africa. We also have the Banking Code. Now, the Banking Code actually highlights some of the obligations that banks have when offering credits to consumers. Those obligations also, of course, mirror or are similar to the obligations in the National Credit Act. But in addition to the obligations that are in the National Credit Act, the Banking Code places an obligation on banks. Number one, obviously, not to ensure that the bank does not offer credit recklessly to a consumer. Two, that the bank does a thorough search on a particular consumer to ensure that that particular consumer offers who is offered credit rather is not going to be over indebted, understands the terms and conditions, and understands what it means to be bound by that particular credit agreement. And of course, in the event that a bank declines rather to offer credits to a particular consumer, you can request from the bank in writing to confirm or to verify, or to indicate to you what was the reason why they declined. They can give you various reasons, of course. Now, in the South African context or South African space, like I've mentioned, we have the National Credit Regulator that regulates the credit space, or it is the regulatory body when it comes to the offering of credit in South Africa. So, in order for a person to have a credit agreement, example of a credit agreement is a credit agreement or contract in relation to your credit card. It's an agreement or contract in relation to your vehicle financing. It is an agreement or contract in relation to your bond that you have with a bank, or any other institution that is accredited to offer credit to your consumer. So there is actually a process that you can follow to have an agreement rather declared a reckless credit agreement. So there are three ways in which you can have an agreement declared a reckless credit agreement. Number one, you can use the services of attorneys who can assist you in declaring your credit agreement a reckless credit agreement. Number two, you can appoint debt counselors who can assist you with having your credit agreement declared a reckless credit agreement. Important, of course, if you use the services of debt counselors rather, you are mindful that debt counselors do charge for their services. Lastly, you can go through the National Credit Regulator. So you can actually go on the National Credit Regulator's website, and you can refer a dispute or a credit agreement with the National Credit Regulator. Not a dispute, you can refer a request to have a reckless credit agreement declared reckless credit agreement. Of course, this is what you do on your own. You need not have a third party assist you. So from our conversation today, I really hope you have some sort of understanding really when it comes to the offering of credits of consumers. I think, or I'd hope that at the very least you have an understanding of what a reckless credit agreement, bearing in mind that there are three classifications in South Africa of reckless credit agreement. Lastly, we end our conversation by saying, really, when it comes to the offering of credit, I think it's very clear in the South African space that consumers are protected to a great extent. What is, of course, is important rather as a consumer, that when you are applying for a credit, you have various obligations. Two perhaps of the most important obligations that you have is, number one, any questions in relation to being offered credit are answered in full. So if a bank is offering you a credit card, a bank is offering you a bond, a bank is offering you vehicle financing, you must always ensure that all the questions in relation to your credit application are questions that are answered in full, and perhaps most importantly, all the questions in relation to your credit application are questions that you answer truthfully. So if it transpires that a consumer withheld information, in other words, you didn't answer or offer your credit provider information in full, or that as a consumer you were untruthful. Unfortunately, you as a consumer will not be able to refer that particular agreement or credit agreement as a reckless credit agreement because you were not honest. We hope you enjoyed our conversation today, and of course, please, of course, remember to subscribe to our channel on YouTube, The Legal Affair.